Good afternoon, and thanks for joining us for the third session of the virtual conference, How the Law Treats Hate, Anti-Semitism, and Anti-Discrimination, presented by UVA's Religion, Race, and Democracy Lab, UVA's Jewish Studies Program, and UVA's Karsh Center for Law and Democracy. I'm Laura Weinreb, a law professor and legal historian at Harvard Law School, and I have the good fortune to be chair and moderator of this terrific panel. A few brief announcements before I introduce our speakers. Following this session is the closing conversation between legal journalist Dahlia Lithwick and legal scholar Micah Schwartzman at 4:45 p.m. If you'd like to participate, please visit the website religionlab.virginia.edu to register. As with our previous panels, we encourage audience members to engage in this session by raising questions throughout the program. If you'd like to ask a question, please use the Q&A function at the bottom of your screens. The chat and raise hands functions have been disabled. Today's speakers will be able to see your questions and will reserve time at the end of the conversation to field some of your inquiries. Please also note that all attendees have the ability to upvote each other's questions. Okay, with that, it is a genuine pleasure to introduce the speakers for our panel, who will be sharing snippets of their really insightful and illuminating work on anti-Semitism and the law. Our first speaker, Elizabeth Katz, is Associate Professor of Law at the Washington University in St. Louis School of Law. And you've already met our second speaker, James Loeffler, who is the J. Berkowitz Professor of Jewish History at the University of Virginia and a faculty collaborator with the Religion, Race, and Democracy Lab, as well as an organizer of this important and timely conference. So with that, I will turn it over to Professor Katz.
Thank you for the introduction, and I'm so glad to be included in this really interesting conference. Today I'll be speaking about the complexity of Jewish identity in the mid-20th century and how that led to special opportunities as well as obstacles for Jewish civil rights lawyers. The fact that Jewishness was understood as both a religion and a race or ethnicity afforded opportunities for collaboration and alliances, as well as multifaceted legal strategies. When facing conduct they found objectionable, Jewish civil rights lawyers sometimes could make a strategic choice. They could develop arguments similar to those in race-related civil rights cases, or they could instead pursue legal change through First Amendment claims. Which path they expected to be winnable changed over time based on politics and developments in legal doctrine. To make this more concrete, I'm going to tell you about a conflict that unfolded in New York City from the 1930s through the 1950s. The conflict centered on New York City's family court, which was the largest such court in the country. The dispute involved leading civil rights groups, including the NAACP and the American Jewish Congress, or AJC. One major component of the New York City Family Court's work was to handle juvenile delinquency cases. When children were found to be delinquent, they were assigned to a probation officer to monitor and reform their behavior. When New York adopted juvenile probation in 1903, probation officers were matched to children based on various facets of their identity. This was true in other places as well. Courts and reformers reasoned that a probation officer of the same sex, national origin, race, or religion might be more successful in rehabilitating the child. In New York, it seemed to many lawmakers and other powerful figures that matching based on religion was the most important. In fact, the first juvenile probation law required religion matching to the extent practicable. This probation law built on decades of other child welfare laws, which required religion matching in institutional care, foster homes, and other contexts. These religion matching laws did not seem controversial to people at the time or for several decades thereafter. Religion was such a salient aspect of New Yorkers' identities that it made sense and seemed benign for the law to require this kind of matching. But in the late 1930s, the religion matching probation law started to seem problematic to some New Yorkers, including several of the judges who sat on the New York City family court bench. Several developments came together to raise questions about this practice. First, Jews and other minorities saw new reasons to be concerned about government consideration of race and religion because of the Holocaust. Whereas tracking children's religion previously seemed protective, it started to appear dangerous. Second, the civil rights movement was gaining steam in challenging racial segregation. Together, these changes led New York to adopt the nation's first anti-discrimination state constitutional amendment in 1938, as well as related statutes. What the new anti-discrimination laws meant for the pre-existing religion matching statutes was unclear and would soon become contested. The third major factor that prompted a shift in attitudes toward religion matching was that the judges appointed to the family court bench were increasingly diverse. For both symbolic and political reasons, Mayor LaGuardia used his appointment power to transform the court from mostly white Christian men to the most diverse bench ever created in the United States by that time. It included, for example, Judge Justine Wise Polaire, a trailblazing woman lawyer who was the daughter of prominent Rabbi Stephen S. Wise. And it also included Jane Boleyn, who became the first Black woman judge ever in the United States. These judges and several of their colleagues and spouses held leadership roles in civil rights organizations. When they joined the bench in the 1930s, they were deeply troubled by the government-imposed identity matching they saw in the court's probation service. By that time, religion matching also caused de facto race matching, which was backed by an informal policy of race matching as well. About half of the city's youth were Catholic, nearly all white, and a third were Jewish, also white. Because of this correlation between race and religion, matching by Jewish or Catholic identity almost always meant race matching. Of the relatively smaller share of the city that was Protestant, the Black residents, many newly arrived from the South, disproportionately appeared in the family court. So it was recognized at the time that that Protestant was often synonymous with Black in this system of organizing child services along religious lines. Both the Jewish and Black judges raised objections to the probation matching scheme, but their colleagues resisted. The Catholic judges in particular supported religion matching and in fact successfully fought to expand it. In their view, it was appropriate and helpful for probation officers to oversee children's compliance with the religious practices of their faith. In the mid-1940s, those opposed to identity matching started to make progress. Judge Jane Boleyn and others cast probation race matching as a form of Jim Crow segregation. Threatening a lawsuit under newly passed employment discrimination laws, they argued that this practice limited employment opportunities for Black social workers and was psychologically harmful for Black children. Caving to pressure, the court stopped the practice of race matching in 1946. But religion matching remained. At first, Judge Polaire and several of her Black and Jewish colleagues attempted to pressure the court to stop religion matching using a strategy similar to what had worked in the race context. The NAACP's Walter White was among those outside the court to join this effort. He explained in a telegram to the New York governor that religion matching could lead to other types of discrimination, including discrimination based on race. This example is indicative of the larger possibilities for cross-group collaboration during this period. But this time, the publicity campaign did not work. Since religion matching, to the extent practicable, was a law, its supporters felt validated in continuing to apply it. The Jewish judges and their allies next turned to the AJC's legal branch, which one of their spouses led, to pursue litigation. The AJC recognized it had more than one possible approach to challenge the religion matching law. It could pursue a First Amendment claim and argue that the probation law violated the separation of church and state. In fact, it had raised many similar arguments in cases in the prior decade. However, by the 1950s, AJC recognized this approach was unlikely to win, largely for political reasons. So instead, the AJC lawyers decided to pursue the issue as a matter of employment discrimination. The family court's presiding judge openly admitted he applied a quota to probation officer hiring. Because only 5% of juvenile delinquents were Jewish, only 5% of the probation officers could be Jewish, even though the city was 1/3 Jewish and Jews disproportionately attended social work school. This meant it was nearly impossible for Jewish social workers to get the family court's desirable jobs overseeing children. In the memo AJC filed with the state's Commission Against Discrimination, the lawyers argued the religion matching law resulted in discrimination against qualified Jewish workers based solely on their identity. This legal path seemed more likely to be successful than a church-state claim because it was politically and legally in line with civil rights cases, in which AJC also participated. Though selecting the more strategic path of an employment discrimination suit, the AJC lawyers seem to have made a miscalculation in their brief. Instead of leaning heavily on race analogies in civil rights cases, they emphasized separation of church and state type arguments. In the interest of time, I'm simplifying a bit, but the result of their suit was that they secured a compromise result that left them deeply unsatisfied. The state's Employment Discrimination Agency determined that though the family court could no longer ask about religion when hiring probation officers, it could still consider religion when assigning them to a particular category of work. In practice, this meant Jewish social workers were hired, but then not tasked with working with children, which was the kind of work most social workers preferred. The AJC lawyers recognized belatedly that they might have been more persuasive if they had tied their argument to race. They filed a motion for reconsideration, this time citing Brown v. Board. The argument here was that it was discriminatory to treat people differently based on race or religion. But we'll never know if that argument would have won the day because the commission did not find a reason to reopen the case. From this episode, I think we can derive a number of lessons. It emphasizes how the multifaceted nature of Jewish identity doesn't cleanly fit in just one legal bucket. Lawyers seeking to challenge discrimination against Jews could sometimes choose between strategies that treat Jewish identity as akin to race or ethnicity, or instead cast the matter as sounding in separation of church and state. This history also demonstrates tensions between religious protections and group discrimination, which of course manifests in many contexts today. For instance, in my new research, I'm turning to the influence of religion in foster care and adoption. In recent cases, courts have heard about faith-based agencies' control over child placements. What religious groups see as protections for their beliefs are experienced by religious minorities, same-sex couples, and others as discrimination. I look forward to discussing this further in Q&A.
Good afternoon. It's a pleasure to follow Professor Katz in our session today. I'm going to be speaking about also some lessons from history and some historical narrative that inform our discussion about race, religion, and rights and anti-Semitism. So I'd like to begin my remarks by noting that we are meeting virtually in Charlottesville, and I want to tell you the story of a riot. It starts with a group of neo-Nazis and white supremacists marching through a tight police cordon. Then, as the rally begins, the speakers denounce atheistic, Zionistic Jews and Judeo-communists who they accuse of taking over the American government and hurting white Christian America. And then, swiftly, things turn violent. Protesters and counter-protesters clash, the police are in the middle, blood flows in the streets. No sooner is it over than a new fight begins, the conflict about the conflict. Speaking to the press, the bigots claim the mantle of free speech. They're the true victims of militant leftists. Many conservatives are horrified, but they acquiesce to an idea that there are crazies on both sides. Liberals, meanwhile, denounce far-right extremism, but they struggle with questions of civil liberties. Should the media give such hate a platform? Is the First Amendment really so absolute? 7 famous words come to mind. The Constitution is not a suicide pact. The scene I've just described might well be Charlottesville in 2017, but it's not. You might think it's Skokie, Illinois in 1977, but it's not. The riot in question took place in Chicago in 1946. Even as Americans were prosecuting Nazis at Nuremberg, white supremacy was on the march, and it was entering or attempting to re-enter American cities. 2 notorious bigots, Gerald L.K. Smith and a man named Arthur Timoniello, arrived in Chicago to revive white supremacy. It was their first stop on a campaign to try and build up white supremacy in post-war America, stop the civil rights movement, and restore American nationhood as a white Christian society. That rally led to a riot there, and it led to a national debate about anti-Semitism and racism. It also led to 2 major Supreme Court cases that will be known to the people on this webinar who are lawyers. Beauharnais, which Professor Forbath mentioned, v. Illinois, and Terminiello v. Chicago. And it was the second of those 2 cases that prompted Justice Jackson, just back from Nuremberg, to make his famous statement about the Constitution not being a suicide pact. Now, I'm a history professor, and I'm the first person to say that history does not repeat itself, ever. But it does provide us with patterns, reminders, and resources with which to confront our present-day challenges. Between Chicago and Charlottesville stretches a long line of debate and experiment about what law can and should do to stop anti-Semitism and other forms of ideological hatred. The thoughts that I'm going to share with you today come from a book in progress about that history. And for time's sake, what I want to do today is cut to the chase and give something of an overview, a meta-narrative, if you will. My argument is that when it comes to anti-Semitism, American Jews have always struggled to fit themselves into the categories of religion and race, just like Professor Katz actually mentioned. Even today, the idea of protecting Jews as a racialized ethnic minority calls forth praise from some quarters and outrage from others. The same holds true for religious freedom. There are some Jews in America who view the expanded application of the Free Exercise Clause as emancipatory, while others see it as a dangerous erosion of separation of church and state. Now, it's common to say that these divisions result from political polarization. As goes the rest of the world, so goes the Jews. We also hear that Israel splits American Jews and that religion or religious observance divides Jews up into categories and then into along party lines. I don't dispute that some of that is true, but I think that these talking points miss a deeper conflict over Jewish identity and civil rights law that complicates efforts to define any systematic, coherent legal policy for combating anti-Semitism. Before we can direct the power of law against anti-Jewish animus, we need to determine how Jews wish to be seen by the law. And I don't think we're going to get there by arguing over whether Jews are white or when they became white. We can't solve this only by arguing, likewise, whether religious disestablishment is good or bad for the Jews. What we need is to develop a deeper appreciation of an ideological conflict that runs through a century, and perhaps longer than that, of American Jewish legal history. The way I would frame this is in terms of 2 groups that I call, respectively, civil libertarians and liberal communitarians. The Jewish proponents of civil libertarianism, or individualism, to use another word that's been mentioned in our proceedings today, believed historically that stripping American law of any vestiges of discrimination against racial or religious minorities and guaranteeing equal protection to individuals would suffice to stop racism and anti-Semitism. Formal equality and civil liberties would ensure liberal individualism, and private enterprise, I think that's an important part of this story, could flourish in a democracy. Individualism was the mantra and groups were the enemy. Jewish liberal communitarians argued that racial and religious equality required acknowledging the existence of different minority groups who faced different kinds of threats deserving and requiring affirmative protection. Political and legal theorists among us know this and often call this difference-based liberalism. Right? These thinkers argued, and these leaders argued, it wasn't enough to proclaim equality and ban discrimination. You needed to take further steps, and the law should do so. And so these liberal communitarians endorsed the idea of hate speech regulation, as well as the idea, in many cases, of affirmative action. Groups mattered, and steps had to be taken to make the law recognize the differences and address them. Now, what I'm describing is a typology based on the history that we already know some of because of the research that's been done by Professor Forbath and others to trace this back in different episodes and points in time. It's a fight that begins already in the World War I era and continues into the Civil Rights era after World War II and then into the 1970s and down to today. Race played a key role in this, as did religion and the interaction between the two of them. But what I want to suggest is that a better yardstick for assessing this conflict and seeing its implications today is visibility. Over the century, American Jews proved themselves to be torn between a desire to invisibilize themselves in the eyes of the law, merging into a majority white population in a way impossible, it should be noted, elsewhere in the Jewish world, and their impulse to seek specific legal recognition as a vulnerable minority group. The episode I began by describing in the 1940s was the first post-war round of this conflict. And then as American Jews faced what they perceived as a dramatic uptick in anti-Semitism, they split again into these camps over the issue of hate speech laws. Ultimately, the civil libertarians won the day, and some of the efforts, vigorous efforts to develop more robust forms of hate speech codes to test them, even when the victories were won in the court, as in the case of Beauharnais, were discarded by American Jews, by some of the same groups. You'll notice as I'm going here that I'm doing this swiftly, but also I'm taking pains not to talk about specific organizations because I think these are trends that cut to some extent in uneven ways across the American Jewish population. In the 1970s, when neo-Nazis marched on Skokie, Illinois, American Jews divided once again. Some thought restraints on speech were obvious and necessary in the face of dangerous anti-Semitism, and others balked. Some referenced notions that actually have come up in today's earlier sessions when we talked about BDS, Israeli-Palestinian conflict. Some talked about dignity and emotions and feelings of people faced with hate speech, and others focused instead on principle or legal protections. Caught between these libertarian and communitarian wings, strikingly, the American Jewish civil rights establishment in the late 70s chose to sit out the fight. They did not file amicus briefs in defense of the Skokie ban, and they basically watched as the ACLU and others went to court to fight this out. Then if you fast forward to 1987, a case comes that we've heard about called Shari Tefillah v. Cobb, in which, to simplify, the Supreme Court ruled that Jews could seek federal civil rights protection on the basis of a racialized minority identity status as non-white. This is a complicated decision. But what I want to stress here is that it provided a moment of opportunity for the exponents of legal communitarianism, the group's people, to claim more protections and to claim a more expanded presence of groupness inside civil rights law as it affected Jews and others. Yet in the end, the libertarian view prevailed. They declined, the American Jewish Civil Rights Group declined to push forward any cases or exercise this option that they had basically won in this very interesting Supreme Court decision. Now, in recent years, a fresh wave of Jewish communitarians have given Shari Tefillah a renewed lease on life. And the twist is that these are not Jewish liberals, but political conservatives strongly identified with the American right. The 2019 presidential executive order and the wave of anti-boycott, divestment, sanctions legislation represents what I would call a conservative communitarian move that caught many by surprise. So today it's the Jewish right, and now there's a new political mapping on top of what I've described that did not exist for many, many decades of this narrative I've sketched out. Today it's the Jewish right that has vigorously pursued and applauded the idea of a legal definition of anti-Semitism and a legal classification of Jews as a group in order to protect them. That this is connected to the Israeli-Palestinian conflict is certainly true, and it's a factor. It's also true that it's a genuine tactical and contingent response by people and activists who perceive a genuine anti-Semitic threat. But the point here is that this is a logic and an argument that is based on an older trend and an older pattern and an older argument about Jewish groupness and group rights inside American society. This new trend has left both Jewish liberal communitarians and civil libertarians conflicted and confused about how they want civil rights law to protect Jews. Many civil libertarians worry that the return of hate speech codes or other forms of prescribing speech will compromise First Amendment principles. Many liberal communitarians worry that their original vision of group protection has been hijacked by political rivals on the right. They further struggle with the issue of claiming Jewish minority status in light of the politics of racial justice and whiteness today. But I actually want to close by noting that I think the most complicated place in the political Jewish spectrum and the legal spectrum is that which is occupied by these new conservative communitarians. As America grapples with a long-term demographic shift from a majority white Christian country to a minority white, vastly more diverse religious landscape, Jewish conservative communitarians find themselves in an odd role and will continue to do so. First and foremost, they tend to advance arguments about legal individualism and about individual rights, often against notions of political correctness and notions of identity politics. And yet, this move and this seeking protections involves asking for a Jewish group status to be recognized in the law. In a certain sense, and I can unpack this more in the Q&A if we have time, this is effectively a majoritarian argument speaking in the language of minoritarians. We can already see some of these contradictions emerging in the debates about policies to stop anti-Semitism. The 2019 executive order targets anti-Jewish discrimination by effectively requiring Jews to be treated as a vulnerable, racialized minority group. Yet, many of its strongest proponents criticize other minority civil rights activism as too politicized and too divisive in its invocation of group identity and strong, thick differences between people. Tying Jewish identity also to the state of Israel and anti-Semitism closely to anti-Zionism also amplifies a tension here between the focus on the American constitutional paradigm and the transnational attachments that define so many Jews and Jewish identities. It also raises the question about whether this could and should be extended to other groups, other minority groups, Palestinian Americans, Arab Americans. And here it's worth noting that the Supreme Court in the Shari Tefillah case back in the 80s tied together a case of Arab American discrimination against an Arab American with the case of anti-Semitic discrimination to consider them together with implications that still remain with us today as we confront attempts to particularize hatred against Jews versus to comparativize or put it in the context of lots of different groups. Now let me conclude by saying this. How this conflict will play out is hard to predict. And I don't think we can have a clear map to show us exactly where it should go or will go. I don't think race and religion are things that we will move beyond, to refer back to the title of this session. But I do think the more that Jews insist on explicit legal remedies to target and stop anti-Semitism, the more they will confront these root tensions between group-based and individualist paradigms of Jewish civil rights, past and present. And ultimately, much of what happens will depend on how American Jews decide they want the law to see them. And I think that's a key factor underlying much of what we are facing and experiencing today. Now, of course, the legal future doesn't only depend on Jewish wishes. What happens with civil rights law, anti-discrimination, and anti-Semitism as a whole will depend on how Americans ask law to treat group identity and groupness. So here I want to close, going back to where I began, by quoting one of the Jewish civil rights lawyers from 1945 involved in some of these responses to Chicago and that first outbreak of white supremacist anti-Semitism. He said, quote, "People singled out for attack as a group have the right to defend themselves as a group." And I'd just like to leave everyone with this question. Do we agree with him or not? Thank you very much.
Okay, so thanks for two really terrific papers. These papers open up some very important and fascinating avenues that we haven't yet thought through today. So I want to take the few minutes I have to reflect on the themes that are in the foreground in these papers, but also some that are a bit further beneath the surface and, in my view, raise some really fundamental questions. So this is a conference about anti-Semitism in the law. One of its premises is that law can serve as a tool to ameliorate anti-Semitism, whether through anti-discrimination law, hate speech law, or some other mechanism. And so the first question raised in earlier panels and in this one is whether and how to recognize Jewishness as a category that the state is empowered to act to protect. We can ask in this vein, and the authors have asked, whether state efforts to combat anti-Semitism will have the effect of reducing or instead perversely exacerbating discrimination. We can ask whether isolating Jewishness as a category akin to race serves to counter racialized assumptions, or rather tends to reinforce the notion that Jews are ethnic or racial others, and thus to legitimate or naturalize anti-Semitism. And similarly, we can ask whether hate speech laws will limit the kind of vitriolic screed that fuel anti-Semitism, or instead, whether it will allow the bigots, as Loeffler put it, to cast themselves as the true victims. That is, will banning hate speech root out hate, or will it instead feed an anti-Semitic narrative that minorities receive better or special privileges, and thereby end up increasing anti-Semitism or driving it underground? So these are difficult questions. They're questions that the authors have posed and that there's much more to say about. They're questions that have consumed Jewish lawyers and advocates for over a century, as we've heard from several of the panelists. It was a central and animating concern for early civil rights and civil liberties lawyers, including the founders of the ACLU and the NAACP, as well as Jewish groups like the American Jewish Congress and the American Jewish Committee. I'll highlight in this context some illuminating correspondence between the first co-counsel of the ACLU, Morris Ernst, and a prominent member of the New York Jewish community. The ACLU at that time was defending labor groups in Jersey City against Jersey City's populist mayor. And Ernst's correspondent wrote to warn him not to repeat the mistakes of Nazi Germany, where through their advocacy and activism in defense of other groups, Jews inadvertently, he said, drew attention to themselves. He writes, "If there is a necessity to defend certain groups or what is considered by some people as the rights of minorities, then it should be possible to find enough able non-Jews to do so." And Ernst responded that he thought, quote, "all members of all religious groups should act like Americans. As soon as the Jews or the Catholics or the Protestants start to act as if they were not Americans first, but Jews, Protestants, or Catholics first, they are conceding the concept," he said, "of a divided America." Now, there's a lot about this exchange to say in connection with the papers. But what I actually found most telling here is that Ernst's correspondent misconceived Ernst's objectives in Jersey City. It was never Ernst's goal at this point in the trajectory of the history of civil liberties and civil rights in this country to defend certain groups. Because as an ACLU lawyer at this point, when Ernst was declaring a right of radicals and labor organizers to gather in Jersey City, Ernst was valorizing individual freedom rather than group rights. For Ernst, that is precisely what it meant to be an American first. Now, this is by far the only, but far from the only vision that was in circulation at this time. But it became, I think, in some ways, an ascendant one over the coming decades. It's a conflict that is a perennial one in American Jewish history. As I said, the papers highlighted beautifully. The former panel also gave us a lot to think about in this connection. But what I actually want to do moving forward is introduce what I see as a further wrinkle that Katz and Loeffler's paper add to this puzzle. So both ask how we define the victims of anti-Semitism, the people who are targeted by anti-Semitism, which is the question we've been addressing. But both also implicitly raise the question whether it matters who is discriminating or enabling discrimination. And what I mean by that is whether private groups or individuals are engaged in hate speech or discriminatory conduct, as in the episodes in 1950s Chicago or 1970s Skokie that Loeffler recounts, or is the source of that discrimination the state itself, as with the probation officers in mid-century New York, whom Katz discusses. And this question, I think, reflects another fundamental division between the various contingents that the panelists have described. Their understandings of democracy and political economy and their attitudes towards state power more broadly. So Loeffler raises this question when he tells us that Jewish civil libertarians believed that formal equality and civil liberties would ensure that liberal individualism and private enterprise could flourish in a capitalist democracy. He also posed, of course, a version of this question to Nomi Stolzenberg in the previous panel. And in turn, Jim, I'm going to pose it to you and Elizabeth this panel. So this is a complicated linkage. I certainly don't have time to unpack it today, but I'll just say you'll have to take my word for it when I say that the earliest advocates of the civil libertarian vision, many of whom were Jewish, fully embraced a strong role for the state in promoting both economic equality and what we now call civil rights. And yet, for complicated historical reasons, the civil libertarian model is now linked with neoliberalism, I think, and a general skepticism toward the administrative state, whereas the communitarian liberals, at least historically, anchored themselves to a more actively redistributivist state. And it's notable in this regard that the quote with which Loeffler concluded his presentation continues in a fascinating passage that he's unpacked in previous work. So here's a longer version of the quotation from the Jewish civil rights lawyer he closed with. People singled out for attack as a group have the right to defend themselves as a group. He goes on to say, this principle has led in industrial relations to collective bargaining. The same principle can lead to equally important results in the field of ethnic relations. For instance, the enforcement of anti-discrimination laws should not be left to individual initiative only, but minority organizations should be given the power analogous to that enjoyed by unions under the National Labor Relations Act to file charges of unfair labor practices. Now, for those of you who are unfamiliar with the contours of American labor law and the National Labor Relations Act, let me just offer the following gloss. The author that Loeffler is quoting here is not just proposing the resolution of group conflict privately through contestation between those groups. He is positing a role for the state in mediating group conflict. And above all, I think that's where the conservative communitarians and the liberal communitarians, to use Loeffler's terminology here, divide. So I want to link this observation about divergent attitudes towards state power to a broader trend in First Amendment law in recent decades, what Justice Kagan has called the weaponization of the First Amendment as a tool for dismantling the regulatory state. Very briefly, litigation under the Free Speech Clause of the First Amendment has been used to invalidate campaign finance legislation, restrictions on commercial advertising, and public sector union dues. Meanwhile, litigation under the religion clauses and also its legislative adjuncts have been used to challenge such laws as the contraception mandate of the Affordable Care Act and state anti-discrimination laws that require equal treatment of, for example, LGBTQ customers by religious vendors. And what's striking about these developments in light of the papers is that while both are anti-state and anti-regulatory, they scramble the traditional buckets of individuals versus groups. In fact, both corporations and religious entities in recent years have acquired new and stronger group rights vis-a-vis the state. So there's a sort of dual tracks. There's a strengthening of individual rights on the one hand, but also actually of group rights. And the conflict, to reiterate, is not simply or primarily about group rights versus individual rights. It's about trust in state institutions to regulate in the public interest. So again, to return to Loeffler's terminology here, the conservative communitarian strand, like the liberal communitarian strand, recognizes a kind of corporatist group right. The difference is that the latter seeks to invoke the power of the state to protect those groups, whereas the former seeks to insulate those groups from state regulation. Though, of course, as with all supposedly laissez-faire endeavors, they draw on the power of the state in doing so. So I want to mention in this context two major Supreme Court cases this past term involving religion. The first professed to root anti-Catholicism out of the law by prohibiting the state from excluding religious schools from a government funding scheme. That is, the court said it was unconstitutional for a state to enforce its commitment to separation of church and state by limiting a state-based scholarship system to secular schools. The second decision claimed to protect religious liberty by expanding the exemption given to religious schools from anti-discrimination laws, at least when it comes to hiring teachers. So the upshot of reading these two opinions together is that rules purporting to shield religious groups from discrimination facilitate the channeling of funds to private groups, which increasingly are empowered by law to discriminate. As Katz mentioned, the court will decide this term whether taxpayer-funded religious foster care agencies can refuse to place children with same-sex couples in contravention of state anti-discrimination law. I know I'm running out of time, so just to wrap this up, we can take this one step further by trying to assimilate this development to President Trump's executive order on anti-Semitism, which has come up in this panel and earlier ones. It's worth noting, I think, that the executive order targets only discrimination sponsored or enabled by public universities. Whatever else the executive order accomplishes, its effect is to further constrain public institutions, even while private institutions and universities that don't accept public funding are insulated from liability for discrimination of all kinds. So I want to close with a question. In its amicus brief in Brown v. Board of Education, the US government could reflect matter-of-factly, and I'm quoting here, "Few Americans believe that government should pursue a laissez-faire policy in the field of civil rights, or that it adequately discharges its duty to the people so long as it does not itself intrude on their civil liberties." The mid-century advocates that both Katz and Loeffler describe very much shared that vision. And Katz's paper helpfully reminds us that part of the mid-century civil rights agenda was to address prejudice directed against religious groups. For AJC lawyers, Establishment Clause litigation, like civil rights litigation, would ensure that the state refrained from inflicting harm on the basis of identity. Today, rooting out prejudice against religious groups has come to mean empowering religious groups to exercise their own prejudices. And I would love to hear the authors reflect on how that trajectory unfolded and whether Jewish advocacy and activism played a role in that transformation. So with that, do you would you like to take a moment to respond?
Sure. Elizabeth, would you like to go first? Okay, so yeah, I thank you very much. As those who are listening to us discuss this know, we wanted to keep this a short, focused conversation, even though these are large issues, and I'm really grateful to Laura for distilling so much of this important context that is glanced at and alluded to in the work I presented and Professor Katz's work too. So thank you. I guess what I wonder about, I definitely see the trends you're describing, and I'm struck by that connection between views of what the public interest is and how the state can interact with it. And I guess what I would ask you, I'd respond by asking you is sort of how we get the periodization right. One of the striking things about recent developments insofar as it has to do with Shari Tefillah and some of these cases is that they all purport to have to resolve a problem that goes back to the Civil Rights Act, where the issue of Jewish parochial schools is the reason that you're allowed to have a certain affirmative discrimination, right, in the Civil Rights Act for religious institutions in 1964, so that they can hire people who match their religious needs. And that carve out, so to speak, is one reason why it's hard to find ways to protect Jews, right, in these cases until you get Shari Tefillah. So without getting back into the particulars of that, what's striking to me is how this is an issue which does go back. And I wonder if the turning point has something to do with the 70s and 80s and the way we talk about legal history and attitudes towards politics in American society, or whether it has to do with certain fateful decisions that were made in the 40s and 50s, which by the 60s simply baked in these tensions that we're just revisiting again. So I'm not giving a straight answer because I'm still thinking out loud about this, but I do think there's kind of a long trajectory, and I'd be interested to hear Professor Weinrib say whether she thinks this is fundamentally new or the shift happened right at that mid-century moment, and then it just took a lot of time for us to begin to see it and groups to begin to activate it.
So I want to give Professor Katz time to speak, so I'll be very brief. But what I would say is that I think that it was still very much, my own research sort of concludes in the immediate post-war period, at which point I think there was a real trend within dominant civil liberties groups in the way they understood individual rights, but in which everything else was still very much up for grabs. I think there was still lots of contingency around this issue. When it happened, I guess, is for those of you whose work, my guess is that it happened somewhere in the period that you've identified between mid-century and the end of the the 60s, 70s. But maybe with that, I'll turn it over to Professor Katz.
Yeah.
Well, thank you for these extremely rich comments, which I'm sure we could talk through all of them and it would be really illuminating, but I'll just focus back on a few of your comments. So I was really struck by your discussion about private parties versus the state and how it matters which kind of entity is performing various conduct that people are experiencing as discriminatory. And I think it's just one of the things that's so interesting is how those categories can blur. And we're seeing that in some of the cases we both referenced, like Fulton, the foster care case, where the line between public and private is kind of messy because of government contracting with private organizations. And I think there's a lot of other places where categories often blur in this history. So thinking about even group rights versus individual rights. Well, when we're thinking about a quota for probation officers, it's affecting individuals, but they want to fight it as a group, in part because it's hard as a strategic matter to find an individual to bring the challenge because that individual isn't being hired. So there's just a lot of blurring and messiness that I think this history can help us tease out, which is why one of the reasons that I'm really interested in looking at this kind of longer trajectory of how religion has been understood and treated. And just one other point, I think drawing on, I think it was some of Nomi Stolzenberg's comments earlier on, one of the other things that's really complicated here is a lot of what the Jewish lawyers I'm studying saw as discrimination wasn't necessarily, even in their view, motivated by anti-Semitism. It was motivated by other religious groups, genuine efforts to protect their own religious interests. So it goes back to some of the questions in the earlier panels about how much intent matters versus how much kind of the result matters. And when we think about religious group interests, we can have different religious groups that are in opposition without one of them hating each other or meaning anything harmful by it. And I think that makes it a lot harder to know how or whether the law should intervene in some way.
I would invite the audience to weigh in here. We certainly have some time for questions remaining. But in the meantime, I wonder if either of the panelists has either questions for each other or other observations you want to bring in.
Sure, thank you. One of the interesting implications of what I hear you describing and sketching out the recent trends with the court is the idea of incorporation, right? And it's striking to think about this as, on the one hand, an idea that goes way back in American law, and is something that helps religious communities sort of think about who they are and define themselves. And yet there's also seems to be something of a, I don't know if it's a convergence moment, but an emerging trend that we see. And I based on what you're describing, one could well imagine, I suppose, that private religious groups could constitute themselves as ways to make further demands on public authorities in the context of higher education, even as they're, blurring the lines and acting as with corporate personality. And I'd wonder whether either Professor Katz, Professor Weinrib, think that's a trend we might see based on where the court is going, that it would recognize that. I'm not a court watcher. In our next and closing session, we have a great opportunity to hear two, court watchers talk a lot about this. But I don't know. Is that a trend? If we're sketching out something and saying, that we're moving towards a reality where different communities, among them Jews, who want to aggressively deal with anti-Semitism, will formalize themselves and make these claims. Sort of this move you've so nicely described of pushing the state out, but asking the state to let them do certain things. And there's a question coming in too from Vicky, who talks about this, whether this is the revenge of Religious Freedom Acts, and whether this is really the long-term consequence of that, forcing this forward.
Professor Katz, would you like to weigh in on this, or on?
Well, I don't know if I have a thought specifically on Vicky's really interesting question, but court watching the Fulton case has been really interesting, and thinking about the role of history in a lot of the amicus briefs and how history can be spun in some ways to support both views. So the people that are supporting faith-based groups' ability to choose to not serve same-sex couples cite this, centuries of religious groups running orphanages and other kinds of child welfare services. But then on the other hand, there's a historian's amicus brief about, well, sure, but government has always been involved in regulating that to some extent. And I think it will be interesting, going back to some of the cases Professor Weinrib was referencing about how Catholic history was incorporated into that school case. It's just really interesting to see, or try to predict, I think hard to predict, which of the historical accounts is going to be more compelling to the court if they decide to incorporate history into their decision.
Mm-hmm.
Great. We've actually got another question from Jessica Lowe. She says she's wondering if the turn to conservative Jewish communitarianism in these cases is reflective or strategic. In other words, is the move toward conservative communitarianism reflective of larger societal changes with respect to LGBTQ rights, women's rights, et cetera, or is this instead strategic impact litigation that's meant to move jurisprudence in a particular way, perhaps using plaintiffs who are more palatable than other possible plaintiffs from the Christian right?
Mm-hmm. I think I'll just respond to that. I think that's a wonderful question, and you can read what I've characterized as this recent trend against Professor Katz's description of an earlier trend, and say, well, wait a second, people always act strategically. Sometimes they mess up, they choose the wrong strategy, but we all know this, that activists and advocates, make choices, and some of the logic of law is about what will stick and what will work in a moment. It's hard to know right now. I'm trying to sketch a long-term narrative to show some things, but then things do scramble. I think it's a nice way of putting it. And I think some of that scrambling is clearly, for those of us who follow closely what the efforts are legally to deal with anti-Semitism, some of it is an experimental approach. Of saying we cannot really go further with First Amendment, so we're going to make other arguments about different types of discrimination, or we face the First Amendment hurdle. And I don't know how that will play out, but I do think some of that is true. And then to turn to Professor Katz's last remark, then it gets post facto justified, right, in terms of saying, well, this is a deeper continuity. We're doing something because of our commitment to this or because of that. As far as the plaintiffs and the relationship between Jewish and Christian groups, this is also something that I think there's very interesting trends happening, and less research than I would have expected about how different groups collaborate and find each other when they deal with these sensitive social issues and the things of that nature.
Great. I think we have time for one more comment if either of you would like to add anything. Otherwise,
yeah, I'll say a very brief comment. If I know some people who join this conversation are interested in actually, as we sometimes say, tachlis, which is practical results. And I do think there's an interesting lesson in the work I'm showing and in Professor Katz's work about unintended consequences. And these are both stories of unpredictable results and unintended consequences that have to do with the guesswork in legal strategy, but also the shifts that take place. So I think that we're in a moment where no one knows exactly where and how all these things will play out, but they might yet have some unintended consequences for the efforts to proscribe anti-Semitism.
Great. So on that note, I'd like to thank our panelists for a terrific set of papers, and to thank everyone who joined our conversation. As a reminder, this session was recorded and will be available on the Religion, Race, and Democracy Lab's website next week at religionlab.virginia.edu. We hope you will join us in just a few minutes for the concluding conference conversation with Dahlia Lithwick and Micah Schwartzman. Thanks again.